I thank the gentleman. We now recognize the ranking member of the subcommittee for his for his questions.
Thank you, Mr. Chairman. Mr. Cohen, you testified that U.S. policies and laws weakening our patent system in key areas, such as patent-eligible subject matter and the availability of injunctive relief, have given China an opportunity to surpass us in innovation. Can you explain in more detail how China has exploited our weakened patent system?
Yes, thank you for your question. To someone who observes IP developments on both sides of the Pacific, it was interesting to me to see that at the same time as cases like Myriad and Bilski were decided by the US Supreme Court, China amended its examination guidelines to permit the very same subject matter, ineligible patents, to be granted in China. Now, this was probably due in some small measure to the US Supreme Court decisions and an opportunity perceived by the Chinese Patent Office, as well as China's own economic growth, that it was becoming very successful in fintech, in genomic discoveries, and medical diagnostics and related areas. So there's a bit of self-interest here, as well as a bit of a competitive edge. Studies that have been done by Adam Mossoff at George Mason, Dave Kapos and others have shown that in many cases patents that were ineligible in the US were eligible in China and the European Union and many other countries. That's one aspect. The other aspect is eBay. In China, injunctions are basically automatically granted if there's a finding of infringement. This is really critical to China because damages are low. So having an enforceable injunction means that you actually have a useful remedy in China's huge market where so many goods are manufactured and sold. So that becomes an attractive position for China to play in attracting global litigation. And I should say that part of this is is by no means secret that China wants to be a center for global innovation. So it wants to attract these cutting-edge industries, and we've seen it with companies like Alibaba and Baidu and Tencent and others. But it also wants to be a center for international IP litigation. And how that evolves is a bit unclear. But they do have a cadre of over 2,000 IP judges, 2,000. And not only that, but many of these judges and IP officials have since been promoted to higher levels within the Chinese government. I think we have yet to appoint a federal circuit judge to the US Supreme Court. China has had at least 2 IP judges appointed as justices of their Supreme Court. And we've seen other promotions within the Chinese bureaucracy. Xi Jinping...
Well, let me stop you right there.
Yeah, sure.
And let me ask you this question. In your view, how would making injunctions easier to obtain make U.S. corporations more competitive with China?
Well, it makes China a more attractive place to litigate. Obviously, injunctions that are abusively asserted will not advance U.S. innovation. But the availability of injunctive relief for those who practice inventions is a significant advantage. There is no doubt in China that injunction is available if there is a finding of infringement.
Thank you. I'd like to ask anyone who cares to respond. I'm particularly interested in the ability of small businesses in advanced areas of technology to be able to grow and thrive. I believe this is one of our greatest sources of competitive strength against China. What challenges do you think that our small businesses face when they try to enter the Chinese market with respect to intellectual property rights that big businesses might not? And are there remedies that Congress should consider in response?
I can tell you that statistically, if I may answer, small businesses have a very low utilization rate of the Chinese IP system. That is small foreign businesses. So you're looking at less than 1% of the patent applications, for example, and probably a very small cohort of the litigation as well.
Why is that?
Some of it is lack of knowledge. Some of it is that small businesses may be focused on the US market and they may be unaware that their products are being infringed, counterfeited, Their information may have been stolen in the Chinese market, so there's that as well. Barriers to entry, such as high legal costs, where they don't know how to secure the proper advice. The USPTO is a great outreach program, the China Roadshow, where we do reach out to small businesses. It was a core part of my function when I was attaché. And I know those have been expanded over the years as one tool that we have, but I think it is a continuing problem, frankly, that small businesses have difficulties enforcing their IP rights in China and frequently don't even take the basic steps of securing the right to begin with.
Thank you.
Ranking Member, I'd like just to add on to the great points just heard, amplify a little bit of a defensive perspective. I see small businesses and startups with a significant inability to protect what they're doing at any cost. So because they are mission-oriented and trying to drive a wedge into the new industry they're trying to develop, they don't spend a lot of money on robust security, CISOs, CSOs, general counsels, people who could advise and inform on the patent process. So what makes them most vulnerable, their inability to protect that from ideation through manufacturing provides an unbelievable vulnerability to attack from the Communist Party of China, which prevents them from getting that foothold in the marketplace.
Thank you, and I yield back, and I thank the chair for his indulgence.
And I thank the ranking member for his thoughtful questions.